Good morning and welcome to Informed Choice. It's a Matter of Ethics webinar. My name is Noreen Jalloway Gill and I'll be your host today. Before I introduce our presenter, I want to make sure you can hear me. So if you can, please send me an email or a message to untwise@unt.edu, or you can use the question box on the webinar control panel to the right of your screen and type yes if you can hear me, or send me a nice little note. I see that Diana's already been actively sending some notes. Hi, Frida, Sandra, Jose, Diana. Good, super. People are hearing us loud and clear. So there we go. Veronica. Oh, Mark, good to see your name. Debbie, super. So good. And if you do lose the hearing and need to call in, I did put in the access number, the dial-in number in the chat box. So if you need that, that information is there. If you have questions during the session, use that question box or email them to untwise@unt.edu, and we'll collect those questions and share them with our presenter. Also, if you're calling in by phone only, please use email. Send an email to UNTWise to receive credit for participation, and we'd like you to do that before the end of the session. I'll provide some more information in regards to the credits for this webinar at the end of the session, but now I'd like to introduce you to our presenter, because today's session is an hour long, so we have a lot of information to cover. Dr. Chandra Carey is an assistant professor of rehabilitation counseling at the University of North Texas with over 13 years of experience in the field. Her experiences include job placement, career development, and she's been a disability specialist for university students, as well as mental health counseling and employment. She is the immediate past president of the National Association for Multicultural Rehabilitation Concerns, and her current focus includes women of color with severe mental illness and rehabilitation outcomes. So thank you, Dr. Carey, for joining us today.
Good morning. Thank you, Noreen. Hi, everyone. Welcome, and I'm so glad that you guys were able to join us. As Noreen was speaking, I just realized I need to send you guys an updated bio. So just a couple of things. One, I'm not just the immediate past president for NAMRIC. There are two past presidents in between. So I kind of circled out of the executive role for that organization. And I also recently received tenure, so now I'm an associate professor, which has all the bells and whistles of more work and committee responsibilities. But that's fine. I accept that gladly. So today we're going to move into talking about the ethics of informed choice and informed consent, and how critical it is for us to make sure that we relay that information accurately and confidently to our consumers and clients. There are so many aspects of our daily duties that we carry out which are directly connected to us maintaining our core ethical principles, that sometimes we kind of are operating on automatic. It's kind of the same situation whereas if you're driving somewhere and you look up and all of a sudden you're there and you don't really remember exactly how you got there, you just knew how to get there. I think we operate that way a lot when we're working with our clients and consumers. Just kind of, it's what we do, and so we just kind of go through and do it. The purpose today, though, is to make sure that we are practicing conscious ethical practices as we're interacting with the folks that we provide services to. I'm going to refer quite a bit to the CRCC, the Certified Rehabilitation Counseling Code of Ethics, because it's kind of the basis and foundation for the work that I do and what I'm familiar with. But I'll also drop in some references to APA or ACA's Code of Ethics. The CRC Code of Ethics specifically addresses aspects of informed consent throughout the document. The very first mention actually is in our first section A, which focuses on a counseling relationship. And there it talks really specifically about what the client's rights are in the counseling relationship. And it's important for us to think about, and I know that we all are very conscious of protecting the client and focusing on their rights, but to make sure that we slow down and that we are really honing in on what's important for the client to know, to understand, and to be able to let us know that they understand as we move through the process. There definitely is direction in the CRC Code of Ethics and how we should operate in regard specifically to disclosure and informed consent. And so today we'll focus specifically on the nature of informed consent and everything that it entails. So we'll just briefly go over, because you can't talk about the Code of Ethics or informed consent without really looking at the foundational ethical principles. We'll have kind of a detailed overview of what informed consent is and the ethical duty that's attached to it. We'll explore ethical practices needed to make sure we are following informed consent, and then we'll discuss some implications to consider when we're serving or assisting our clients and consumers. So I like to include quotes. Anybody who knows me knows that I find that there are people who say things way better than I can. And so I like to use this quote specifically when talking about ethics. Ethical practices, for most of us, are kind of ingrained in who we are and what we do. Like I said before, we kind of operate on automatic pilot, and this is kind of, we know that we're supposed to practice ethically, and so we do that. But there are those times when there can be conflicts between what our professional ethical code tells us, what the policies within our organizations and agencies tell us, and even between our own, those things in our own personal ethical and moral codes. And it's here where we're in that setting, in that situation where there's that conflict, where we might lean one way, believing that it's the best way to respond and operate that way and have no consequences for it. And so we just continue to move forward with that. And what I want us to do is to be much more conscious in how we're thinking about some of the minute and mundane details of what we do every day. And I think informed consent definitely falls into that realm of how we think about our overall practices. So there are a couple of reasons why you want to do an applied ethics training. And I think some of you are here definitely to get continuing education credits, which is perfectly acceptable. But I think that one of the most important things here in regard to why we want to cover ethics, and specifically for us today, informed consent, is that it just keeps us on our toes. In my current practicum courses, the students have to record the beginning part of one of their counseling sessions where they discuss confidentiality, which is something that we all do as a part of our practice in providing services to our clients. What they also have to do is kind of critique that recording, and inevitably, as they review this very critical part of the session and the client-counselor relationship, what they sometimes notice is either how fast they've gone, how they may have stumbled over some information or important concepts, how they may not have given the client time to ask questions, and so on. There are even some cases where they're not the person who goes over informed consent or confidentiality. It's something that's handled by an office assistant or another individual that sees the client and goes over the general paperwork before they come into their counseling interaction. So when they are reviewing it and kind of going over it, when they assess themselves, and students are always really critical of themselves, more so than they probably need to be from time to time. But what we've noticed is that, or what I've noticed is that they realize that maybe they didn't spend enough time talking about consent, confidentiality, the limits of confidentiality, and the client's protections and rights as they should have. And we'll have a case study a little later on that will kind of reveal some of the consequences of not spending enough time on those very important concepts earlier on in the process. So what I'm hopeful that this session will do is kind of increase our ethical sensitivity to informed consent and the very critical role that it plays in the overall relationship we develop and build with our consumers and clients and the services that they receive from us. As I go through this, I do have kind of a stop point in a couple of slides where I'll kind of ask if anybody has questions or anything to that effect. But if you have questions prior to that, do feel free to either email or use the chat function, and we can address those as we kind of go along. So here are our golden five. Underlying the foundation of the CRC Code of Ethics, the ACA Code of Ethics, the APA Code of Ethics, and the Marriage Family Therapy Code of Ethics, most of the clinical human services codes of ethics are based on a foundation of ethical principles. And these ethical principles were initially kind of devised in the early 80s, and they included those concepts that some of them are very central to the work that rehabilitation providers do. Autonomy to promote self-determination, non-maleficence, to avoid doing harm, beneficence to make sure that we promote the well-being of others and our clients, justice to be fair and equitable, fidelity to make realistic commitments and keep promises, and more recently added was a concept of veracity, and this is to be truthful and to deal honestly with our clients. Looking at the two concepts of fidelity and veracity, those are the places where you'll find that the concept and the practice of informed consent is really closely related. To make sure that we're making realistic commitments to our clients, we're keeping promises, we're giving them full information so that they can make the best decisions, which kind of takes us a little bit back to autonomy, and that we deal honestly with our clients. And so there's a lot of full disclosure that has to happen at the very beginning of the counseling interaction so that we can ensure that the client is guaranteed their autonomy to make appropriate choices and decisions based off of the information that they've received from us regarding the services that we're going to provide. So what is informed consent? For most of us, it's kind of a form we sign off on. I recently went to a new physician, and as I was going in there, you get your kind of introductory paperwork, and included in that is all of these different forms. HIPAA's included in there. There's an informed consent. There's kind of disclosures, who you can provide information to, all of those things. And so as I was sitting there, definitely with this presentation in mind and going through the paperwork, one of the things I pondered, because no one really talked to me about the information, they just kind of handed it to me, which is common practice, and told me to sign off on it. One of the things that I thought about was, what if I wasn't able to fully understand and grasp all of the concepts presented in the information? What if this was a new process to me? What if I was unfamiliar with it? What if I didn't have the cognitive capacity to fully interpret all of the information? Me signing off on it, because that's kind of the expected mode of operation, wouldn't necessarily indicate that I fully understood it. And so it's important, as we think about informed consent, that we really focus on this concept of due process. And that really just means that we're allowing a process to occur where people receive full information, they're explained that information, and they're able to make a decision. So they're given, and this kind of goes back to our ethical principle of justice, is something that's fairly revealed to them, so that they can, and fairly and equitably revealed to them and other folks, so that they can make the decisions that they need to. In 2003, Corey and Callahan, researchers who focus a lot on counseling and counseling practices, asserted that the failure to obtain or document informed consent happens to be one of the top practice areas that has the greatest general legal risk, and is one of the top practice areas that is most often not given enough time and attention to by the counselors that they surveyed. So given that and knowing that, we know that we need to spend a little bit more attention talking about informed consent. Most services or agencies and organizations will generally provide those forms, and that's perfectly acceptable. But what I want to talk about today in our conscious effort to practice more ethically is that as you have those forms signed, as your clients or consumers are going over the information and agreeing that they understand, that we take a little more time, which I know is a stretch because our time is really tight, and the things that we have to achieve with the client or consumer and the time that we're working with them is tremendous. But that little extra time really does help us to work to our best ability to protect the client, consumer, to protect the agency, to protect ourselves, to protect our profession. So when you have that that form that you provide, written consent is kind of the rule. This is generally what happens. You provide consistent documentation for informed consent, and that's important because that helps to maintain that ethical principle of justice. It's something that everyone sees. It's standardization of the content. Again, that promotes justice. It gives ease of administering it so that you can, yes, easily have someone sign off on it to guarantee that they understood what it says. And it's pretty much the community standard. But there are those times where it is important that you should also discuss verbally what the client or consumer is signing off on as they're going over that documentation. And what that requires of us as providers is to make sure that we know what the person is signing. How do we understand and what do we know about the limits of confidentiality? How do we understand and what do we know about record disclosure? How do we understand HIPAA, which is a task in and of itself, and we'll talk a little bit about that in just a little bit. We want to make sure that when we're providing informed consent, we're going over all of the potential benefits, the potential risks, consequences, our reporting responsibilities, the duration of the treatment or services that are going to be provided, how many different providers they're going to come into contact with, so that they can make a deliberate choice about the services. And this deliberate choice really does go back and harken back to another core concept at the heart of being rehabilitation professionals, and that's to make sure that we are protecting the autonomy of the individuals that we're working with, and that we're allowing them to have the right and making sure that they have the right to make the best choices for themselves and the treatment or services they might participate in. So the next couple of slides will talk about all of the different things that can be included in informed consent, and there's a lot. And so I won't go over all of these, but I will highlight some specific areas that I think are kind of important for us to remember as we move through the process and as we're talking through some of it with our consumers or our clients. Generally, as I mentioned before, the whole concept of informed consent really does focus on rights. We want to make sure that they have the right to make autonomous, voluntary decisions about participating, and that they understand the benefits and risk. And they also have a right to understand the alternatives to treatment and what happens if they're not satisfied with treatment. These are things that should not be glossed over. I think no one wants to say, well, if you're not satisfied with what I'm doing, here's what you can do, because our ultimate goal as helpers is to make sure that we are helping and people are satisfied with what we're doing. But it's important for us to make sure that we do provide that information too, so that they, one, are being promoted to, again, have that autonomy, but to also know that they have the right to advocate for themselves if for some reason they are dissatisfied. So you're going to talk about your role in the relationship, the counselor or the provider. You want to talk about the limits to serve in an advocacy role. So some of you might be job placement and development, you might be job coaches, you might be rehab counselors. There's a whole spectrum of different positions that you might be in, and some of those will require you to advocate in a certain way. But we also want to make sure that our clients understand that we are not kind of the persons who are going to marshal every cause that they have. We have to practice within the scope of what is acceptable and policy at our agencies and organizations. And so it's important that we relay that to the clients and consumers as we're working with them. One of the things that I think is really important to talk about when you're talking about informed consent are the limits on confidentiality. When you're in human services, when you're in rehabilitation counseling and you're a service provider, the interaction and the relationship that you build with the client, a lot of that rests on your ability to develop a relationship with that person. And the ability to develop that relationship is closely related to your ability to facilitate trust and a safe environment. And oftentimes, those concepts of trust and safety are synonymous in some clients' eyes to confidentiality. So it's really important that we talk specifically about the limits to confidentiality. So if I were to quiz you guys really quickly on the limits to confidentiality and ask what they were, particularly here in the state of Texas, I'm sure some of you would say that that would include issues where there might be risk of harm for elder or child abuse. There might be an issue where records are subpoenaed. There might be an issue or situation where the person is alleging to cause harm to themselves. And those are kind of the common areas that we think of. Another major context for a limit on confidentiality includes billing and insurance issues. And we tend not to think about that very often, but that's an important concept to relay to the clients because some of the information that we record, some of the documentation that we hold will have to be translated to insurance agencies for billing purposes. Our CRC Code of Ethics talks specifically about that in Section G, where it talks about evaluation, assessment, and interpretation, and also in Section E, where it talks about consultation. So it's important for us to make sure that we relay insurance and billing issues as another potential limit on confidentiality so that the client understands that. So let me talk about one specific area of confidentiality that has some I guess, myths surrounding it, specifically in the state of Texas. So if you guys are familiar at all with the Tarasoff decision, this was a decision that was made in the mid to late 70s, I think 76, in the state of California, saying that you have, if you are someone who provides services, there is a limit on your confidentiality such that if you are subpoenaed, or such that if someone makes a harmful, threatening statement regarding a specific individual, you are open to alert that particular individual. This is to provide protection for the greater good. And the Tarasoff decision is one that's been adopted by many jurisdictions across the nation. However, the decision has not been formally adopted in the Texas Code because the Texas Supreme Court has not created a new common law cause of action that's based in negligence. And this is really important for you to understand. The Texas statutes provide few express limits on confidentiality and thus very few legal protections for professionals who breach it. So you should be sure to read Texas Code 611 of the Texas Health and Safety Code carefully before breaching any client confidentiality to ensure that such a breach would fall within the protected limits. Again, some of the more general areas where there are limits to confidentiality is suspected child abuse, elder abuse, or dependent adult abuse. When there's a threat to kill or harm oneself, and that's communicated, and for insurance and billing situations. Situations involving a threat to someone else where there's a reasonably well-identified victim is something that you really want to be very careful with. Hopefully, none of you guys will come into contact with any situation relative to that or any of those particular breaches of confidentiality. But if you should, it's important for you to be aware that you specifically articulate that to your client or consumer so that they're also aware of information that they might share that will fall outside of the traditional role of confidentiality that you and that person would share. This kind of connects a little bit to the duty to warn requirements, and I probably should have connected those two together because it specifically really focuses on that. Lastly, you want to make sure that you're talking about disclosure information at your particular agency or organization. That will vary place to place. When I was in the state of Michigan and I was practicing as a what's equivalent to an LPCI here, I was required by the state licensing board to create a disclosure form. That form pretty much relays what my counseling practices or theoretical background is, how I work with clients, how I bill clients, what the fees or rates are, insurances that I accepted. It was a very detailed form, and some of your agencies might have disclosure information in regard to billing and costs and things of that nature. That's also important for you to review with your clients. You also want to make sure that you're talking about your role, if you have any at all, in determining eligibility benefits. You want to make sure that you talk about how you would report results. You want to talk about disclosure from the client and on the client's point of view on what that disclosure might look like or mean in various situations. And you also want to make sure that you visit a little bit with HIPAA. So some of your agencies or organizations might have separate forms for you to complete for HIPAA, and that makes perfect sense. HIPAA is a very detailed, explicit federal law that is intended to protect the client's medical records and other health information. And so you want to make sure that you cover that very specifically for them. And if there is a separate form, that you still do spend a little bit of time talking about HIPAA. So I am not a HIPAA guru by any means, but I do know that what HIPAA does is that it provides clients with access to their medical records, and it gives them a little bit more control over personal health information. the act was intended to make sure that there was a nationwide floor, kind of a nationwide foundation of privacy protections. So states can establish more stringent laws that are without being in violation of HIPAA, but there is a minimum level of protection that all individuals receive underneath the HIPAA Act. And so you want to make sure that you talk specifically about that if that's something that you would come into contact with, or that the client or consumer should be aware of as they're receiving services from your particular agency. Again, HIPAA is sometimes a separate and pretty lengthy document that will also be signed. But the other things you want to talk about are kind of the last 2 points that I have here, and that's talking about potential negative consequences from information that's disclosed by the client, and then talking about the consequences for failure to disclose. So we're all helpers. We're all intent on making sure that what we do works for the good of our clients and that we operate so that we don't cause harm. And so the question is, well, what could be the negative consequence if everything that we're doing is to work to their benefit? Well, there are some really specific negative consequences that can come from participation in services. If we work underneath the idea that all of our services are to improve the person's life and that will cause them to shift and to change some of their prior behaviors, some of their prior acquaintances in some issues, particularly if you're talking about people who have substance use disorders, maybe changing their environment, all of these different things can have some negative consequences, and it's important for us to visit with those as we're talking about the overall informed consent with our client. We don't want to belabor those issues because we don't want them to think, hey, is this a good idea after all? Because definitely receiving our services to benefit them is a good idea, but they do need to be aware that there's a potential that they'll have a worsening of symptoms. There's a potential for increased relationship problems as they start to shift and change in order to improve their life situation. There's a potential in some instances for crisis because they're just not sure how to handle all of the changes and what's new and what's burgeoning in their lives to improve their overall situation. So we want to make sure that we talk very briefly but specifically about some of those negative consequences. And then we also want to talk about the consequences, the potential negative consequences for them not disclosing. So if we're working with clients, and it'd be nice if our clients and consumers came in and gave us all of the information, but we know that that's not the case for various reasons and for various past experiences that they have. They might hold some information back. We might not have the full story. And when we're trying to provide services that are going to enhance their overall lives, having full information is really important. It helps us do our best job. When we don't have all the information, then we might be operating off of what they've provided us, premises that we have based off of the information they provided us that might not, after all, be in their best interest. And so we want to make sure that they know that potentially the work that we're doing might not have the overall great benefits if we don't have all of the information from them. And this kind of harkens back a little bit to what I was talking about in regard to confidentiality kind of being closely related to trust and safety. You know, our clients and consumers, particularly those who have been involved in systems and services for quite a while, may have negative experiences, may have negative perceptions of what service provision can look like. And it's up to us to make sure that we make them feel safe, that we make them feel as though they can trust us, and that we illustrate and demonstrate that same level of trust for them. That helps to create a relationship where doesn't necessarily mean they're going to give you the whole truth and nothing but the truth, but you can then press a little bit more to say, it seems like there's something you're not telling me. We've got the basis of this relationship. I hope that you can, because I want this to all work for you. And in order for that to happen, I need all of this information from you. The last couple of things that are generally included in a thorough consent exchange, again, and I talked about this earlier, are appeal rights within the agency. So clients or consumers should be aware of what the process is should they have a negative, what they perceive to be a negative experience with you or a negative experience with a service provider that you've connected them to or another vendor. They should really understand what the process is for them to contact someone. So I remember when I was working in Michigan and I was providing professional disclosure statements, at the very bottom of it there was a number for people to call for the licensing board if they felt like they had an issue. Well, one of the persons that I was working with, I was working at a comprehensive rehab agency that provided services to persons with mental illnesses, general adjustment issues, and persons who were psychologically adjusting to newly acquired disabilities. Well, I had a client who had a cognitive impairment who called the licensing board because they were unsure of whether or not they were supposed to meet with me every day or every week. It was just a really interesting situation when they were telling me about it. The licensing committee contacted me only to make sure that my professional disclosure statement included that information because it wasn't something that was clearly defined previously. There wasn't any kind of penalty for it or whatsoever. But because I didn't take the time at that point to really specifically talk about what their rights were in regard to appealing and what that meant and how they would go through the process of appealing if they were dissatisfied with services, that was kind of the consequence of it. A light consequence, definitely, but one still in the same. Generally, your professional disclosures will also include kind of what your background is, your scope of practice, and then any certifications or licenses that you hold in order to be a qualified service provider. Okay, so the last section I want to talk about before we go into looking at our case studies is to really focus on this concept of capacity for informed consent. On your PowerPoints that I sent out, if you were all able to read the notes, I really did struggle with using the term capacity because I don't want it to be linked or likened to the concept of functional capacity because I think that persons with various disabilities can and do have the capacity for informed consent. However, there are those situations where individuals are not capable of giving informed consent, where you're talking about minors, you're talking about vulnerable adults, and it's important for us to make sure that we provide an appropriate explanation to the persons who are signing on their behalf and obtain agreement for participation from a legally authorized representative. Our Code of Ethics, the CRC Code of Ethics, specifically addresses this in our Section B, which talks about client rights. In that section, it talks about the responsibility to minors or clients lacking the capacity for consent and what our responsibility is to clients. So B5 reads, and I'm going to read this verbatim, when counseling minor clients or adult clients who lack the capacity to give voluntary informed consent, rehabilitation counselors should protect the confidentiality of information received in the counseling relationship as specified by national or local laws, written policies, and applicable ethical standards. So as I was reading over that, I was like, wow, that's still a little vague. And I think that is the challenge for some folks with the Code of Ethics. The Code of Ethics is not prescriptive. It's not going to say, if this happens, this will happen. If you do this, this is what should happen. It really does. It is a guideline. It is kind of a form for you to really think about how I should behave professionally, how I should practice professionally, and what would be in the best interest of the client. So in looking at that particular statement in regard to individuals who might not be able to provide informed consent, I then visited with other codes of ethics to see if there was more specific information. And what I found in the APA Code of Ethics Section 3 is that it talks about that we should provide an appropriate explanation, we should seek the individual's assent, we should consider that individual's preferences and best interests, and explain all of the information that we would have explained to the client or consumer in the same way to the legally authorized person. If there's a situation where substitute consent is not available, then we as professionals need to take reasonable steps to protect that individual's rights and welfare. And what that essentially means is that we need to locate someone who would be available to provide that consent. We want to make sure that the client or consumer has the ability to understand all of the information, and if they are not, that we're relaying that information in their presence to an authorized individual, a legally authorized individual. We also want to make sure that they have the ability to withdraw consent. And this is something that's very important, such that if for some reason the individual that has been authorized or the guardian that's been working is making decisions on behalf of the client, and the client or consumer is articulating that they disagree with those decisions, then we want to make sure that the client or consumer is aware of our agency's policies and procedures. We're aware of our jurisdiction's legal policies and procedures on how to address that particular issue. At the end of the day, when we're talking about informed consent, what we really want to do is make sure that we're protecting the client. By protecting the client, we're protecting ourselves. And by protecting ourselves, we're protecting our agency and also our profession. And it's really important. That's probably a point that you'll hear me say a couple of times here. But it's really important we think about informed consent in that broader scope of what it actually is versus just a piece of paper that we pass over to our clients to sign off on at the beginning of our interaction. Okay, so that was a lot of information, but I want to stop here and see if you guys have any questions or comments before we move into looking at one of our case studies.
Sure, we have a couple of comments that we can review, and again, I'll just, all of our participants, you can certainly write any information in the question box, and I'll pick that up and share it with to our presenters. So let me start off with, I think this was early on, and there was a comment that time spent with the person competes with time spent with forms. There's never enough time. So, and you pretty much covered that in your presentation. There was a question about what are some accommodations, tools, or assistive technology we can use when working with a person who has an intellectual developmental disability, traumatic brain injury, or other disability that impairs cognitive functioning.
Okay, great question. Let me address the first comment. The person who talked about the time spent with the person competes with the time spent with forms is exactly right. But I think it's really important to try to incorporate all of that together. The more familiar you are with your forms and with the information that's translated in them, the easier it is for you to move a little bit away from the form, talk and have an interaction, a relationship building interaction with the client, and still cover the necessary information that's in the forms. So you can have a conversation with them talking about who you are, what they're there for, and then you can embed information about informed consent and say, well, let me talk to you a little bit about your rights, and then go over that information without leaning so much on the form because you're so familiar with it. And that's been a way that I found that works really well when talking about, when trying to get all of the agency forms and responsibilities in at the same time you're trying to build that critical relationship. The second question in regard to intellectual developmental or cognitive impairments is a great question. And one of the things that I think is most important is to try to really figure out what works well for that particular individual. So while I could list off what some of the common accommodations are, you could of course record some of the information regarding informed consent. You can modify the language from the informed consent forms so that it is much more concrete and less abstractly put than sometimes what we find in our forms. And those are general things that might be helpful. But what I think is really important and what really does help are constant check-ins and examples. And so you might say to a client who has an intellectual or developmental disability or cognitive impairment, when you're talking about limits to confidentiality, you might relate to them that things that you tell me are going to be just between you and I. But there are times when I might have to tell other people. What does that mean to you, or how do you understand that? And then kind of check in with them to see what their response is. And then provide an example and say, so let's say that you want to take time off from work because you have a personal family engagement that you want to attend. But the employer that we're working with has a policy that within the first few days of work or first month of work, you have to be there every time you're on call. You're trying to find a way out of that. Me working with the employer, that puts me in a difficult position because I might say to that employer, this might not be the best time for that person to start their job. You want to make sure that you just provide, and that might not be the best example, but you want to make sure that you provide examples that the person can relate to, that fits their situation, for each of these different concepts. And it also helps to kind of take out, similar to how it looks in the PowerPoint, and bullet some of those different concepts so that it's not paragraph text that, again, can be a little bit overwhelming and can impact the ability for someone to process information at a rate which would allow them to understand and then sign off on it. So then when you bullet it, you can stop after each one and say, do you understand that? What is that? What do you think that means? So that you can have a conversation with them about it. Definitely when you're talking to people who have intellectual or developmental disabilities or cognitive impairment, you need to slow everything down so that they have the ability, based on their or persons with mental illnesses, to use their processing speed to the best of their abilities within their functional capacity so that they fully understand what you're relaying and can agree to it in a voluntary nature.
Okay. Oh, that's a lot. So, we did get another question, and that I'm glad that we are recording this so that we can review this and provide information as people ask for it. But the next question we had was, when I am going through the discovery process for employment, what should I write on my report? Sometimes the person wants me to know something, but not write it in the report, such as behavioral issues. I share the report with the person, the DARS counselor, and the family. I'm obligated to provide information that impacts the employment placement.
Oh, that is a fantastic question. That actually would be a great question for our follow-up session next week. Ethically, you have the responsibility to present the information that's requested in your report as it's presented to you. So if you have information from psychological evaluations, if you have behavioral observations, if you have other documentation, and that's a part of what's required in your report, you're not able to exclude that, and not ethically should you exclude that based on the client's preference. And this is something that, again, needs to be talked about up front with the client. As you're talking about evaluation and assessment, you definitely want to make sure that the client understands that there is information that might come out during this evaluation process that maybe doesn't represent the way that you see yourself or your capacity based on the assessments that we've provided. However, ethically, I'm still obligated to include that information. However, what you can also do, though, is provide counter information. So if there are behavioral issues that the person experiences and that's something that you've observed or something that came out through the assessment process, you include that in the report, but then you also include aspects of the client that are positives, that, again, things that you have behaviorally observed or things that they did well on the assessment, so that there is a balance of information regarding who the individual is. And we can spend a little bit more time on that next week. I can take you to some specific places in the code and then also talk about some specific examples that address that very issue.
All right. Well, that's it for now.
All right, great. So let's spend just a little bit of time now. Those are some great questions. Let's spend a little bit of time right now just looking at a case of proper disclosure and what can happen or what it might look like when proper disclosure is not provided. So the case is here for you on the screen, but I'll read it out for you as well. Kathy has been assisting Philip in developing a home-based business in antique brokering. Initially, Kathy felt the business to be more of a hobby than an actual business, and for the first year, Philip barely broke even. Kathy believed the activity was very important to Philip's emotional well-being and that earnings were secondary to his improved mental state. She told Philip that he would not have to be concerned about losing SSDI payments that he had been receiving. Philip's earnings increased dramatically in the second year, in substantial part due to the acquisition of a very valuable piece of art that he found at a garage sale. Kathy was able to close Philip's case, reporting his annual salary as reflected by the current year's income in the case file. The state VR agencies routinely send the Social Security earnings records from closed cases for reimbursement purposes. This information is considered common use and is shared without further consent requirements. When Philip's earning information was reviewed by the Social Security agency, his disability benefits were terminated based on his recent income. So here is a situation where there was some level of disclosure that might not have occurred between Kathy and Philip. What are some of your initial thoughts about what I've revealed so far about their interaction?
And our participants can certainly feel free to include any information in the question box. I'm waiting for their response. Seems like there was some confusion between whether it was a hobby or a business.
Mm-hmm. I think Kathy felt that as well. It started off as a hobby, but those substantial earnings that he had that had to be reported may not necessarily have even been enough to be a business for Social Security, but it is still reported income. And so because of that reported income and the information sharing agreement, it still had to be provided to the Social Security Administration.
Right. The false statements about not being concerned about the loss of SSDI came from one of our participants.
Mm-hmm. So overall in this case, as you guys are continuing to kind of think about it, Philip really felt that he wasn't properly informed about the information sharing agreement and that the information that was provided really wasn't accurate, since the current income was just based on that 1 year, which he happened to have that pretty lucky acquisition in. He believes that there might be little likelihood of him finding something similar to that to make such income off of, and so his earnings don't necessarily reflect the true nature of what he's doing, and what he considers to be more of a hobby than a means of earning a living. So the big question here is, did Kathy properly disclose to Philip how the information he provided to her would be shared? And what we see just from the basic information here in the case is that it's likely that Kathy didn't, and the person that mentioned the false statements about not being concerned about losing SSDI is important, particularly when you're talking about people who are doing antiquing. We know that antiquing can sometimes be a very lucrative business, even if this is something that started off as a hobby. Kathy should have talked about in her informed consent overview with Philip that she had requirements for reporting income, and that it's possible, and this is a potential negative consequence, is that at any point in time that his income past a certain point, the Social Security Administration might look at that and consider removing his benefits based off of how much was acquired or what that income was for that reported time frame.
We do have a couple of comments that came in regards to the benefits issues, and one of those from Mark is that it seems that the case closure was predicted, predicated on what amounts to a sales anomaly. This, coupled with a rather disingenuous statement about needing SSDI benefits, calls the behavior of the professional into question.
Mm-hmm.
And then you have to give a thorough benefits analysis explanation, remembering how much their benefits impact their lives. This is a good example of how full disclosure may seem spurious at the time, but would have a big impact.
Definitely. Kathy had an ethical responsibility to make sure that she followed her agency policy and to share with her clients the possible outcomes of that disclosure. And it seems as though that's something that didn't happen in this particular interaction. And so on that level, as we mentioned before, when you're kind of going over informed consent and disclosures, things can sometimes be rushed and can sometimes we're just kind of very lax with them because it's just a part of what we do. We're on that autopilot. But it's really critical that we spend time with this and make sure that the client understands at every step so that they're aware of what the potential negative consequences might be for them receiving our services. As a CRC, specifically for Kathy, she has to ensure that her clients are fully informed about those negative consequences, and we can see from this particular interaction that that's something that she did not follow through. Given that, Philip would have the right to file a grievance with her at her agency, potentially with the licensing or certification board. It varies. Again, this area of informed consent and documented informed consent is one of the areas that poses the greatest legal risk, one of the top areas that poses the greatest legal risk for practitioners. So it's important that even though our time is stretched, that we find a way to make sure that we clearly articulate all of the different aspects that are included in informed consent and disclosures for our clients. So this is another, I just like cartoons. I think I picked this up from Dr. Leong. He was one of my faculty members when I was working on my master's degree. And as I came to UNT and he was here, I found that this is something that he still included in his presentations. And so I found this as I was looking up ethical dilemmas and thought I would share it with you. So there's a little cartoon here where the person says, "Thanks, but I can't accept that gift. I was just doing my job." And in the next frame, "No, I'm sorry. I'm not supposed to disclose customer information." And in the next frame, "Of course, I can't let you see someone else's bid." And then finally, while they're in the training class, they kind of mention, I'm sorry, my screen is a little bit, my GoToWebinar panel is a little bit in the way. I didn't move that out of the way, Noreen.
No, you're good. He basically says, "I don't have an example. I wasn't faced with any ethical situation." Yeah.
Thank you. So this is an example of a person who's operating on autopilot, but operating on autopilot very much so grounded in ethical situations. The challenge for this individual, though, is that even though they're on autopilot and they seem to be grounded in our ethical principles, we don't know how conscious that is. And it's when we're not operating consciously about our ethical practices that we can sometimes come into trouble and find ourselves in conflict and experiencing ethical dilemmas. So I think we're all familiar with what ethical dilemmas are. It's when we have the choice between two courses of action. There's a potential consequence associated with us going one way or the other. We find that both of those actions can be supported by our ethical principles, and sometimes choosing one course or the other will support one ethical principle but compromise another. When you're talking about informed consent and you're trying to make the decisions about whether or not and how you relay information, how detailed you are when you relay the information, how thoughtful you are about accommodating how that information is relayed, you're definitely protecting autonomy, you're definitely protecting fidelity, you're definitely protecting justice, beneficence. I could maybe list all of them. But there are times, similar to what we saw with Kathy, where she really was trying to promote Philip's mental health and well-being, and that was her really focusing on beneficence, that we find that overall justice was a little bit compromised in that case because she wasn't as fair to him, because she didn't reveal, and her veracity was somewhat corrupted because she didn't really reveal the truthful outcome that could potentially happen from him being successful in his venture. This case study is another example of when our ethical principles collide. And I'll read this to you here as well. It's on your screen. But it talks about you being a rehabilitation caseworker at an assisted living facility for individuals with Alzheimer's and dementia. Your client, Alma, recently experienced a severe stroke, which impacted her memory further, her cognitive ability to process and understand information, along with aphasia, which impacts her speech. Her daughter, Janice, has assumed medical power of attorney to assist and monitor her mother's care. Following a recent appointment with a physician on site, it was noted or discovered that Alma had stage 2 lung cancer. After speaking with the doctor, you informed Janice. But Janice is adamant that Alma not be told about her newly acquired disability. Obviously, there are ethical issues there, but there's also some conflicts that exist there. What do you think might be potential ethical conflicts in the principles that we uphold between meeting Janice's request?
And while we give people a couple of more minutes to think about that and send in their comments, we did get one additional comment on the previous story, and it was misinformation or lack of referral to the right resources, such as a benefits counselor, is also ethically wrong.
Yes.
So it's being informed and up to date with what is possible. Okay, and we're waiting on responses to the current story about Janice and Alma. One comment that Alma needs to be told because she'll need to be making decisions in the future as a medical power of attorney. Then we have one other comment, beneficence versus veracity. Mm-hmm.
Well, in lieu of time, or because of time, let me just kind of work with those couple of comments that we have. In the first comment in regard to Alma needing to be told, that person is exactly right. Our code of ethics lets us know that it's important that our clients should have the freedom to understand what treatments, services they've been experiencing or they're going to experience, and that if they're going to participate in ongoing services, they need to have the ability to make informed choices regarding planning and to make decisions. So in that respect, Alma definitely does need to be made aware of this newly acquired condition that she has. For the second comment in regard to beneficence versus veracity, if you think about this, and if we take off our practitioner hats for just a second and think about this in regard to our possible family members or people that we know, we can certainly understand what Janice's perspective is and where her viewpoint is coming from. And given what Alma is experiencing already, we have to kind of consider what is going to be the potential negative consequence for her having this information. Will that make her disengage from treatment? Will that make her withdraw? Will that initiate some additional depression for her to deal with that would impact her overall recovery process? We have to think about that, but then we also have to think about that truthfulness that we've got to uphold for Janice. And so this goes back to looking at the ability or inability to give consent. In this particular situation, it's not clear to us whether or not Alma is unable to provide consent, even though she has a medical power of attorney who is making some of those decisions. Alma still needs to be involved in the decision-making process. Although Janice might be the person who would ultimately make decisions for her medical treatment, Alma still has every right to understand what is going on with her, what her services will look like, what her treatment plans look like, and what she's going to be participating in. And so our code of ethics in this particular situation, even though our principles are conflicting, is relatively clear in how we should proceed in this particular situation. And we should have both Alma and Janice present as we review what our agency's policies are toward moving forward when this particular situation occurs. It might happen that Alma might need treatment outside of what she can receive at the assisted living facility and from that physician, and so she needs to be made aware of that. And so we do need to really talk through that with both Alma and Janice present. And although Janice does have medical power of attorney, we have to go back to Section A of our Code of Ethics and really look at the client's rights and who our client is. And in this particular situation, although we are working with family, Alma is our immediate client and our immediate concern. And so we have to relay that to Janice so that she's aware of what our responsibilities are ethically. Now, with Janice having medical power of attorney, it's essential that she was also involved in the informed consent process earlier on so that she's aware of what our responsibilities and ethical practices are so that we can refer back to them at this point in time with this particular conflict.
Good. We did get a couple more comments, but one of them was that they did not agree with the decision by the daughter and that she would have to disclose the information.
Yes, definitely. So as we start to wrap up now, these are just a couple of our takeaway points in regard to informed consent and how it really does honor this aspect of autonomy. We want to make sure that clients are able to deliberately decide whether or not they want services, to participate fully in our client-centered planning and interventions, and to make educated decisions about services that will serve them best. What I provided here, just for you to kind of take away if you need this information, is additional content on HIPAA so that you can review that and also articulate that in a way that is best for the clients or consumers you're going to provide services to. The last point I want to say is that consciously practicing ethically, and I've mentioned this before, is good for the consumer or the client, the practitioner, your agency, and our profession overall. So I hope that you're able to do so as you work day to day. In our next session, what I would like to do is to continue to focus on some of the questions and comments that you all have, similar to what you posed earlier. And so if you'd be able to send me any scenarios or questions that you have that are specific to informed consent and ethical practice, then I can work on those over the week, and we can use our next meeting as kind of a working session to go through some of those scenarios and to share them with your peers in case they might have had similar experiences or might run into similar experiences at some point in the past. I'm sorry, at some point in the future. And you can email those to untwise@unt.edu.
Super, absolutely. Just a reminder for everyone, this is a two-part webinar. It's 2 hours or 2 credits will be given. And so we will see you all next Wednesday at 9:30. Please mail us at untwise@unt.edu your examples or your questions in regards to ethics, and we'll pick those up and review those for our session next week. Thank you all for your attention. And I will be talking to you. We'll be talking to you next week. So thank you, Dr. Carey. You have a good day.
Thank you. Thank you, everyone. Have a great day.
Bye-bye.
Bye-bye.